been put in place in the state and perhaps across Nigeria. And one of the things I had hoped by the end of today's discourse is to have more defense lawyers and to have us increase the number of plea bargain applications that we will be getting or that we will get, particularly from the magistrate courts. And I will sort of share reasons why I say I'm looking forward to more applications from the magistrate court. So, I mean, we know that one of the cardinal principles of criminal justice in Nigeria is that, a person is presumed innocent, and that the prosecution bears the burden of proof and must prove it's, charges beyond reasonable doubt. But we all can say that, knowing the criminal justice system that we find ourselves, that we know we have a huge number of awaiting trial inmates. And I will focus more my discourse on Lagos State, because as at today, and this is just from statistics, we have about 7,000 awaiting trial inmates across the 5 correctional facilities in Lagos. And you will agree with me that there's a lot to be done. The numbers are alarming, and I believe that with the use of plea bargain, restorative justice and community sentencing mechanisms, these numbers can be reduced significantly if we have the cooperation of the defense counsel and the prosecution counsel, and of course sensitizing the inmates about these options, the availability of these options when they are being advised. But first, let me just, throw a poser and find out how many of us have one time or the other used plea bargain. If you have, you can just use the raise hand button and tell us whether just by a raise of hand, show or indicate that you have used plea bargain, you have made an application to plea bargain in Lagos State. Can any of us? I just want to understand if you've experienced plea bargain in Lagos State. So if we have, I would like us to, by a raise of hands, show that we have applied to the DPP's office or to the Attorney General for plea bargain, if we've made any application on behalf of a client. I can't see any. If you use the raise hand button, you have, okay, I see one. Thank you, Barry. I see one. What? For what reason? I don't know what reason we have why we're not using it, but I will first of all just take us through what is applicable in Lagos, which I'm sure majority of people on this group are aware of. So I'm not going to dwell too much on it. We know what plea bargain is. I'm not going to define what plea bargain is. But I will attempt to just make reference to the provisions of the law that talk about plea bargain measures. So we know that section 75 and 76 of the Administration of Criminal Justice Law of Lagos State makes provision for plea bargain in Lagos. We also have similar and very robust provisions in the Administration of Criminal Justice Act. And it's essentially covered the whole of Part 28 of ACJA covers plea bargain measures. And I think one of the major thing is to ensure that when considering plea bargain, when the Attorney General is considering plea bargain under Section 75 and 76, that it should only be accepted in the interest of the public, the interest of justice, and the need to prevent an abuse of legal process. And in accordance with the ACJL, we know that there has to be a commission of the defendant must have been charged. So you plea bargain as far as Section 75 and 76 of the ACJL law is concerned, there must have been a charged before the court. It cannot cannot before then. Plea bargain cannot be used prior to a person being charged. It envisages that somebody would have been charged for a criminal offense before a competent court of jurisdiction for the offense, before negotiation between the prosecution and the defendant can begin, can commence. And of course, even after the negotiation, the court is subject to the approval of the court. And there are provisions in Section 76 that guides that process. And a plea bargain can be in two forms. You can have a charge bargain, or even more than two forms, but the most common forms are the charge bargain and the sentence bargain. And during this process of negotiation, we know that the law stipulates that a judge or a magistrate cannot participate in the discussions between the defendant and the prosecutor. However, the law permits a judge, upon being approached by counsel to advise, generally in terms of the possible advantages of discussions and sentencing options of a proposed agreement. In my view, just reading these provisions again yesterday, and I thought, in practical terms, it appears difficult to implement if this is not properly managed. I beg your pardon. And the judge may be, sliding down and ultimately descending and becoming more submerged into the arena, the discussion itself. So it's a really thin line. Provisions, the provision of Section 76. I want to look briefly into what is the role of defense counsel, because I find that and I'm hoping that this can be some form of interactive way of finding out why a lot of defense counsel, particularly at the magistrate court, why are they not using plea bargain? Why is there a particular reason? I would want to at some point maybe hear from some of our participants here today why they believe why they're not using it. I can immediately suggest a few reasons, because I have, from discussion with some of my colleagues, they've sort of given a few reasons. But I want to go into the role of the defense counsel in plea bargain, in entering into a plea bargain agreement. And I want to divide it really into three parts, mainly that, to ensure that the plea bargain agreement complies with the provisions of the ACJL, because you're there to protect the interest of your client, which is the defendant, to ensure that their rights, the right of the defendant is not infringed upon, and also to ensure that whatever sentence is agreed or reached is appropriate. And so, the section, I want to just also to look into Section 76(4) that talks about the plea bargain, that it must be reduced into writing. It's not something we can orally discuss. It must be reduced into writing. I must state, the provisions of Section 76(4) states that, cautionary words must be administered, and the agreement must state fully the terms of the agreement, if there are any admissions that have been made, and very importantly, it must be signed by the defendants, the prosecuting counsel, and the defense counsel, the defense lawyer, where the defense lawyer is represented. And if there's an interpreter, in some cases where we have defendants who are not, who need interpreters, the provision to have an interpreter also signed can be embedded in the agreement. And the process in Lagos really is, where a defendant wants to enter into plea bargain, with the process is to, first of all, having discussed or conducted with your client, you write an application to the DPP's office, or the Attorney General's office, and you state the request. that you intend to initiate a plea bargain, and you then, in the plea bargain, you itemize or you highlight what offense, what your proposal is, whether you want a charge bargain or you're looking at a sentence bargain. Usually the application goes through a committee. You have a plea bargain committee, which was set up as far back as 2015 to look at the applications and make recommendations to the Attorney General for his approval. And in some cases, the Attorney General can or may accept the terms proposed. He may modify, or he may, if he feels that it does not serve the interest of the public, he can refuse the terms. But whatever the circumstances, whatever the decision of the Attorney General is, the prosecuting counsel will communicate same to the defense lawyer. But we find most applications that come from the defense lawyers are usually just, there's no, it doesn't contain any information. What they're proposing isn't contained in there. They just apply and say they're interested in plea bargain, and that is it. And you then leave it to the prosecution to then begin to offer you the lesser offense. But I think it would be helpful where, defense counsel make the application. Within their application, they set out, they set out the willingness of the defendant to admit the criminal liability, and also outline the proposal to resolve the matter, what they are proposing. They want to set out, the sentence that they are recommending, if there are any ancillary measures or dispositions that they would like the court to make. For example, if you want to return a certain, if it's a monetary, you want to, you would like to refund some money, or you would like to send, I don't know, the victim to school, or further education. You can state as much information inside your application, and that will significantly assist the plea bargain review committee to review your application. But most importantly, what also I have observed is that the sentencing, most times, the defense counsel, because they do not propose any sentence, or when they propose the sentences, they're just too ridiculous. If, for example, someone charged with armed robbery, and then the defense counsel is asking for 3 years imprisonment, don't forget that, plea bargain is, it's a three-way, justice is a three-way thing. It's for the victim, it's for the society, and it's also for the defendant. And so justice must be seen to have been done in the circumstance. But I want to take us through very briefly on plea bargaining and sentencing, because I believe that both plea bargain and sentencing, they share similar or very several similarities, because both require some form of understanding, a clear understanding of the facts leading to the crime, the commission of the offense, and also the circumstances and the socioeconomic status of the defendant. And so it's important that as defense attorneys, you understand where the prosecution is coming from when sentences are being proposed. So if, the prosecution doesn't just sit in the office and, because they don't like Mr. A's face, they decide to give him, 5 years or 10 years. There's a guiding principle, and what guides the prosecution is the sentencing guidelines and also the plea bargain manual. So we have factors that must be considered, that must be taken into consideration before recommending a sentence. And I think if, as a defense attorney, you understand what the prosecution, the factors that the prosecution have to consider, it will also assist in during the negotiation process and in applying for and in recommending a sentence in the course of your in your application. And the sentencing guidelines, for example, gives a number of steps to consider before a court arrives at this sentence. And if we're able to do this and we're able to understand this process, you find that even when the agreement comes before the judge or the magistrate, the likelihood of the judge accepting such application or such agreement is very high, because the judge is also thinking along the same line, because they are also guided by the sentencing guidelines. So, it prevents the scenario where the judge is questioning the sentence, because if the judge or the magistrate uses the same or uses the same sentencing guidelines that the defense lawyer had put in use in recommending the sentence, and what the prosecution has also considered in accepting such recommended sentence, it shouldn't be too far off from what the judge would have, the sentence the judge would have given. And I just want to, there's some steps to consider before arriving at a sentence. And one of it is, whether the statutes allow discretion in sentencing. If there is no discretion, then there's nothing the judge can do. The judge is constrained to giving that sentence. So, for example, I think in the criminal law of Lagos State, there are about maybe 3 or 4 mandatory sentences, which is murder, armed robbery, robbery. I think attempt. No, attempt isn't a mandatory. But in essence, if you have a charge for murder, the judge does not have a discretion to reduce or to vary that sentence, and so the judge will have to, or the judge or the magistrate will have to sentence to death by hanging. Also, the sentencing guideline makes provision for culpability and harms of category. You have to consider the starting point, the category range. You look at the facts of each case. When your client gives you the facts of the case, or you pick up your client's case, you look at some of the aggravating and mitigating factors in that case. Also, surprisingly, I'm sure maybe a lot of us know here that when there's a guilty plea, automatically entitles the defendant to a reduction of 1/3 of the applicable punishment that is prescribed by law. And so sometimes, when I see a matter in court and, the defendant on his own, pleads guilty, and before the next adjourned date, when he gets a counsel, the story changes. It's about, I'm changing my plea, I'm not pleading guilty any longer. I think, it worries me, and I think we can begin to educate ourselves and educate the people that we represent, to let them know what that a guilty plea automatically entitles them to some form of reduction in the sentence to be prescribed. And I was just going to have us do a scenario. Bayo, I hope I'm not. I hope I'm still here.
Please go ahead.
Thank you. So I was going to share my screen and have us participate in a short scenario. I just want to, we can put our answers in the chat box. But if I'm allowed to share my screen, I would just like to pose a scenario, and I want to see what the reaction of some of our defense attorneys will be looking at that scenario. And if we can work out the sentence in this particular instance. Okay. So this is an example of, it's just a case scenario, homicide-related offense. And I think this will help us, this exercise will sort of show how to use sentencing guidelines. It will assist both the prosecutor, and I know this is for the defense counsel, to determine whether the case is suitable for plea bargaining or not. So this is a scenario, and I'll just read it out. So Tara is facing charges of manslaughter, contrary to section 222 of the criminal law of Lagos State. And she's accused of causing death of her brother-in-law, Shola. On the 1st of April 2020, she stabbed him in the chest with a kitchen knife. And Tara was living in the family house with her brother-in-law and other members of the family because her husband had traveled to the USA in search of, better life. She lives in the family house with her younger children, 3 of them, and has a shop in front of the house where she sells food and groceries. Tara is small in size. She's petite. She's 5'2", and her brother-in-law is much taller, bigger in size, and constantly makes, sexual advances at her, which she often rebuffed. And then they were often constantly arguing, and this resulted in a fight. So on the day of the incident, Shola hit Tara on the chest, and then Tara slapped him, and he thereafter beat her continuously. During the scuffle, Tara was able to grab a knife, a kitchen knife, and then stab Shola in the chest. And when he fell to the ground, she ran to the police station to report the incident. Upon returning with the police, they met Shola dead in a pool of blood. And then Tara was found guilty and convicted of involuntary manslaughter. Now, the punishment in section 227 of the criminal law of Lagos State says that anyone who commits the offense of manslaughter is liable to imprisonment for life. Now, having looked at what the steps I had mentioned earlier in the sentencing guidelines, I'm not sure if a lot of us are familiar with the sentencing guidelines, but the sentencing guidelines enumerates some steps that must be applied in this sort of scenario. And one of the steps is, we know that manslaughter is not a mandatory sentence, correct? So it also makes provisions for culpability, degree of culpability. And so in this case, what would you say the degree of culpability is in looking at the facts of this case? I would like us to, you can unmute yourself, you can raise your hand. What would you say the degree of culpability is in this case? Can I have somebody? You can raise your hand if you'd like. Do we have anyone who's willing to? Okay, thank you, Don Akebu. Sorry, that's what I can see. Can you unmute Don, please?
Yes, can you hear me?
Yes, I can hear you. Thank you.
Very well. From the scenario you painted, I would like to say that the degree of culpability is minimal or small. I wouldn't be able to situate it because this is the first time I'm seeing anything about sentencing guideline. But from the scenario you painted, I would like to say that the degree of Tara's culpability is small. Yes.
Thank you very much.
The degree is minimal. The degree of her culpability in the light of the scenario you painted.
Thank you for that. I'm just going to go back and
That's
share.
my contribution. That's my view.
Thanks. So you have in the sentencing guideline makes provision for high culpability, some of the what must be demonstrated
Hello?
to constitute. Hello. You can go back to unmute yourself. Sorry.
Hello?
Okay, so I'll continue. I've muted you, done. So I will continue. I'm going to go back and share the screen. And so the degree of culpability, so if it's a high culpability, some of the factors include, was the defendant, was it a group, the offense, was it committed, was it a group action? Did the defendant play a leading role in this in this case? Was there use of weapon in this in the case? Was there's vulnerable person, whether vulnerable person, the victim, a vulnerable person, whether elderly, physically challenged, or if it's a low culpability, there's some of the factors include, lack of premeditation, whether the defendant showed remorse, whether there's some form of mental or emotional disturbance, maybe caused on the family or, within the community, whether there was a voluntary disclosure of the offense. And so if we're to apply this to the fact, I would say is that the defendant, we know from the fact that the defendant did not intend to kill Shola, and that the defendant went to the police station and disclosed this the incident to the police, and that the deceased, we know, was the defendant's brother-in-law who had been making sexual advances at the defendant. And we can see that the defendant has also showed some form of remorse. So in this instance, I would say the level of culpability is a low culpability. If we're applying the sentencing guideline, we're applying the facts of this case vis-a-vis the sentencing guideline. Now, we need to look at the level of harm that is caused. Now, the sentencing guideline also makes provision for harm categories for homicide-related offenses. And you have severe harm, you have substantial harm, and you have limited harm. And in considering the level of harm, we know that the act of the defendant, caused the death of the deceased, and that the defendant's action also caused the death of her in-law. And so I would categorize this as, being a substantial harm. And then the next thing I would proceed to do is to now calculate what sentence should be recommended in this sort of instance, given the scenario. And in my view, I would say that, there's a table in the sentencing guidelines that sort of helps with this calculation. And it may not be 100%, accurate. Whatever recommendation you come up with at the end of the day may not be 100% accurate, but it will not be far off from what the court will eventually recommend, having applied the sentencing guidelines. And you can look at the table. The table also makes provisions for starting points and category range. I want to try to show you a table. So for example, I've just sort of highlighted it as. So for example, an offense which has serious harm and high culpability, the starting point for such offense will be 80%. And then the range, it has a range. So you have it between 80 and 100%, depending on the aggravating and mitigating factors. And that would help you to determine what range to place the sentence. And so whilst one with limited harm and low culpability has a starting point of 50% and a range of 30 to 50%. I'm sure with time, when we have the sentencing guidelines or we have the range, it will help us in calculating and recommending sentences for plea bargain when you want to make your applications for plea bargain. So in order for us to calculate Tara's sentence, right? We said it is life imprisonment. That's what the law says. Section 227 says offense of manslaughter, you're liable on conviction to life imprisonment. Now, life imprisonment in our law at the moment can be our judges, it can be a term of years. The judge can give a term of years. Some judges give the natural life imprisonment, but we don't have a definition for life imprisonment. And so international best practices, I'm just using 25 years as best practices to help you understand how sentences are calculated. And so in this particular case, in Tara's case, I found that her level of culpability is low, even though the harm caused is substantial. And the starting range is 40%. The starting range is 40% and the range is 40 to 50%. So I'm starting with 40%, given the mitigating factors that I had earlier enumerated on. That she has younger children at home. She did not intend to kill the deceased. So we're using 40%, and 40% of 25 years imprisonment will give us about 12 and a half years. Right? And so if you are to recommend sentence, and you want to have, you're having a plea bargain, you have a plea bargain application and you want to recommend sentence, you can then sort of understand where to begin your negotiation from with prosecution. And you know that if you propose 3 years, there's no way 3 years will fly, because there's no, prosecution will not accept 3 years. And so you will know how to start your negotiation, because you already have an idea of what, if the court applies sentencing guideline, what the possible sentence will be. And so you can begin your negotiation from there. And the more you do this, and I want you to put this to use, and I think it would really assist. I also want to just briefly touch up on the time frame for processing plea bargain. When you make your applications for plea bargain to the Office of the Attorney General, it doesn't take time. It's usually subject to a maximum of 4 weeks from the date the application is submitted. And so, it is not something that, will take forever. And I want to, encourage us, and to also, take the message to some of our colleagues who are not here today to see how we can apply plea bargain, in some of these offenses. I found from statistics that, in the corrections, in the correctional service today, we have at least about 42% of those awaiting trial are there for minor stealing offenses. Some of them have counsel, defense lawyers, and they keep going to court and nothing is coming out of this. And this, some of these people have been in custody for maybe half of the time, the offense that they would have served. So, I mean, if I was a defense counsel, I would apply for plea bargain in some of these cases. And if you are able to educate or sensitize your clients about the options of plea bargain or other diversionary measures, I'm sure the issue of decongestion will definitely be significantly reduced. I want to first of all stop here. I don't want him to seem as if it's a lecture. Should we have any questions or contributions, I would like to also hear from some of our very distinguished senior in this field. Thank you, Bayo.
Okay, thank you very much, Bola, for that. So you see, because I see Dr. Akin Bello here. So Dr. Akin Bello, would you like to add something? You've been doing these trainings since last year, so perhaps you could tell us why some lawyers are not using the opportunities for plea bargaining.
Okay, great. very much, Chair. I want what I don't really have more to add. What I think is that for those colleagues who participate course, we had a conversation at this justice, and the product of that conversation was that we need sensitization about death at that level. Because some of the colleagues who practice at the magistrate, if you organize a workshop at holiday, you probably will not find them. But that's the one that practice at the magistrate court. And we know that over 85 to 90% of cases are tried at the magistrate court. So I think it looks as if there's an issue. Hello, can you hear me?
We can hear you. There's a lot of breaking interruptions there.
So, oh, okay. Breaking and interruption is probably a factor of internet connectivity. Okay, can you hear me now?
Yes, carry on, Doc.
Okay, so the point I'm trying to make is that we need to carry our sensitization of defense counsel to the magistrate do their work. If we can do that and let them know about that the legal government has done something that will begin to get to appreciate the value to them as a defense to their clients. And if they do more of them, so it's just kind of a way of anything to realize that's all I want to say.
Well, there was a lot of interruption there. I'm not sure if as many of us got what Dr. Bello said.
So can you hear me now? I can summarize it in one minute. Can you hear clearly now?
I can hear you, so maybe you can try again.
Okay. The gist of what I'm saying is that to improve the practice of plea bargaining in magistrate courts, we need to take the sensitization as to the value of plea bargaining to defense counsel and to defendants, to our colleagues who practice at the magistrate courts. We need to take sensitization to them. And the FPA can assist in this regard as well to organize work at the magistrate districts. That's our colleagues practice so that we can spread to them.
Okay, I think one of my solutions to that would be if we probably shouldn't make it an MBA thing. Maybe we should just make it a Lagos State Judiciary thing where we you can go into the courts and have an open court session on the subject, because a lot of these defense lawyers are in court every day. They're probably there right now trying to handle their cases. So they can't be online. But if you take Igbo for instance, and just take an empty courtroom in Igbo and call all of them inside that courtroom, including their clients, including the family of their clients who are all hanging around there trying to perfect their their bail and all that. Say, all of you come into this court, you want to perfect your bail. Okay, these are one of the steps. One of the steps is plea bargaining. One of the steps is community service, this and that. So we probably should discuss this with the Lagos State Judiciary to give us a courtroom in all the magisterial districts and have a calendar and make sure that everybody comes. The other thing we can do in this regard is to actually, again with the judiciary, because we in Ikorodu worked a lot with the judiciary in order to accomplish a lot of things. We can have magistrates begin to specifically mention these opportunities, these laws in, every day when they handle criminal cases. So that's another way of going about it. I don't know if there's anybody else who wants to make a suggestion on this. Is the DPP still online? If the DPP is still online, we can. We have some criminal defense attorneys here who also have probably specific experiences they would like to share before Bola continues. Anybody? Just let's see your hands if you, or at any point in time indicate while Bola continues to speak. Thank you. Okay, DPP. Hello, Ma. You can unmute your mic and speak.
Okay. Good morning. Oh, good afternoon. Good afternoon, everybody. Yes. I've been listening to what everybody's saying, and actually, we are thinking in the line of what Mr. Akade has just said, in the sense that still the need to sensitize and the defense counsel out there. So actually, the CBC plan to have something like bargaining week in all the magistrate districts, and this will help to sensitize it. And of course, we are still putting together the modality of how it's going to take shape and how we are going to go about it. So once that is done, we'll let everybody know. And in every magisterial district, we are going to have something like that. And hoping that this will help popularize plea bargaining. Thank you.
Thank you very much, Ma.
Back to you, Mr.
Thank you very much, Ma. Can we have Rukayat Oyejola, and then after that, Honorable Babatunde Ogala is also here. Please unmute your mic.
Yeah.
My fellow convener, please unmute your mic.
Yeah. Can you hear me now?
We can hear you.
Good everyone. This is a very good one and a good submission from the host. I really appreciate that. And well, to me, I think the most defense counsel, I would say, only do the job when it comes to advising or probably letting the defendants know what they are supposed to know at the beginning of the case. Like given what they are hopefully, it's like rightly suggested, they're probably taking it to the level it works. I hope so. And well, sensitization do work a lot. At the same time, even at the level of high court, sometimes it's not only at the magistrate court, even high court. In case, because most people believe at the level of high court, they can still get themselves out of it. Okay, maybe probably the prosecution do not bring witnesses, yes, eventually the matter will be struck out, and it's always come from our lawyers, our colleagues, advising them on this. But by and large, I just have a question. My own question is this. According to the speaker, she mentioned that, okay, at the level of writing an application to the DPP, what are the steps? Okay, like the steps she has highlighted. Then she was suggesting that the council should know the kind of plea or the kind of bargain she will opt for, like the number of years she will plead for. So what are the suggestions? Like the scenario she painted is like, okay, 12.5 years, okay, 12 and a half years. Can the first council come with like maybe, okay, a bargain of 8 years? Would that be considered? Or most likely maybe 10 years, or they have to be, because what I've experienced so far is anything they decided to give or they have decided to give, they normally give it. They don't even bother to come down, no matter how you play or whatever you do. Talking from my own experience, I'm sorry to say that it will not be, I'm not generalizing it, but no matter what if in the first instance, the first application we are trying to apply, you have written, highlighted all the fact of the case, the history of the matter and everything, like she has suggested. In fact, I really, really appreciate that. I never considered that in writing my applications before, but now I think I need to do. So, and in highlighting, can we highlight at the same time, bring the suggestion of the number of years at that time? Okay, after doing our feasibility studies, our survey, like, okay, considering the fact she stated, okay, 12 and a half years, can we also add, seek for maybe 8 years or 7 years? That's my question. Thank you very much. I don't want to take the time of the.
Okay, thank you, fellow convener. We missed you in the beginning when we were introducing.
I'm sorry.
The program.
I joined a bit late.
So I think Bola got that. So let Bola hold on that. I don't know if Honorable Ogala wants to say one or two things. Honorable Ogala, are you there? Okay, I think we can just move on to Bola then. Bola, can you sorry, okay. Okay, carry on, sir. Honorable Ogala, we're hearing you.
I said there's nothing to say for now. I just wanted you to know that I'm still here.
Okay. Okay. We'll hear from you later then. Okay, Bola, do you want to go ahead?
Sure, thanks. The question, I didn't quite catch it, but I think from what I got from your question, if please correct me, is that you want to know whether it can be reduced to further to about maybe 10 years. Is that what you said? Sorry, I didn't quite catch the question. Mayo.
Yeah, well, basically what she was saying that I understood was, it seems that when you do a plea bargain, sometimes the prosecutor already has made up their minds as to how low they can go. So even if you go lower than that, it's, the concept is a bargain.
Okay.
So the understanding of what a bargain means is a two-way street and not a one-sided thing. So it seems like there's no bargain if either doesn't want to take, if the prosecutor doesn't want to budge.
Okay. I think you said it, it's bargain, but there must be a basis for that bargain. You can't just say, this is what for example, the calculation we gave from the scenario, and then you say, can you give 6 years? There must be a basis for it. Why are you, what is the circumstance that warrants the grant of 6 years? You must be able to justify the reduction. So if there's a mitigating factor that you feel that, the prosecution did not consider or is yet, or is yet to consider, there's something you want to draw to the attention of the prosecution, don't forget that this is also going to go before the judge. And the judge can, if, you know, the provision of the ACJL is, if you give such a low sentence and the judge intends to go higher, the judge can inform the defendant, notifying the defendant that, you know, this, you know, they don't agree with this plea bargain agreement and they intend to go higher. And so forth. So the provisions of ACJL section 76 is clear on when the judge intends to go higher than the sentence recommended or agreed in the plea bargain agreement. So it's important to have, if you're going to negotiate with the prosecution, I think there must be a basis for that negotiation. And your negotiation must be substantiated, given the facts and circumstances of that case. So if you want to say, oh, you know, time spent, you want the prosecution, for example, to consider time spent awaiting trial as part of this. You know, those are some of the things you push forward in the course of negotiation. Okay, so it won't just be you asking for asking's sake. And I think that is what a lot of defense counsel, I think they don't substantiate their request for a reduction in sentence. There must be a basis for that reduction, and you must substantiate your request. So I think if you do that, it's a negotiation. You know, that's what plea bargain is. You negotiate, but there must be a basis for negotiating. Okay, I hope I answered that question.
Well, it is clear to me, though. So if it's not clear to Mrs. Olabi, maybe she can reiterate her position. However, I think you can still go on with other aspects.
Just touch on aspects of restorative justice. You know, restorative justice, in my view, I think in 2 years ago, you know, we made the courts actually commissioned restorative justice courts, magistrate court, and you know, for a lot of us who know what restorative justice is, it's, you know, it's a process where all parties, you know, in the case come together to resolve collectively how to deal with the aftermath of the offense. And for me, I think restorative justice is a different way of thinking about crime and conflict. It's not the regular way we would think about, you know, when someone commits an offense, it has to be punished. Sometimes, you know, punishment may not achieve the ultimate purpose. And I think for restorative justice, the focus is holding the offender accountable in a very meaningful, in a more meaningful way than the punitive measures that our system of justice operates currently. For restorative justice, it repairs the harm that is caused by the offense, and it helps to reintegrate the offender, you know, back into the community. And you know, there's this sense of healing for both the victim and the community when you have where restorative justice is applied. And in 2018, I believe, where we had a practice direction in restorative justice, and you know, so in the practice direction, there were categories of offenses in which restorative justice can be applied. It is not in all cases, but in some cases, I will come to highlight those cases where the practice direction says you can use restorative justice. And restorative justice, you know, involves at least the victim and the offender in some cases, and also the community, the victim, the offender, and the community, depending on what type of conferencing, victim offender conferencing or mediation you putting in place. And for me, I think restorative justice is so, as I said, you know, it's a different way of looking at crime. It gives the victim a voice. It provides a voice and opportunity for the victim to participate. But oftentimes, you know, in the regular criminal justice system, the victim is not, does not really participate. The victim voice is not heard until when it is usually the state versus this so and so, Mr. Lagbaja, you know, and the victim only comes in when it's time to give evidence. And after the evidence, oftentimes that is it. And unlike restorative justice, where the victim has the opportunity to be involved as early as possible and be fully involved in the process. But one of the most important things with restorative justice is that the offender actually takes ownership and takes responsibility. If the offender is not willing to take responsibility, then you cannot have restorative justice. And so that ownership of crime, that I admit that I committed this crime, is very difficult to do. And you find that most of the cases, if you agree with me, most of the cases that you find in court, it's difficult to find a defendant who will say, I did it and I'm willing to make amends. But where you find that this is happening, or you find a defendant willing to take this ownership and own up to the crime, and the victim is not opposed to having this matter mediated, then I believe a victim offender mediation can take place in that instance. And as I said, in other jurisdictions, restorative justice can be used for any type of offense, including capital offense. But I believe in Lagos, we're taking it step by step, and we start with the minor offenses and see how best it works, or to see how it works before considering them. Once the process is reviewed, then we can consider extending the process to other category of offenses. One of the other benefits of restorative justice is that it repairs the harm caused by the offense. Because when you have people, the victim is able to state his mind. Sometimes the victim of the offense just wants to know, why me? Why did you come to my house to steal my money? Why was it me? And oftentimes, when you have after a mediation, a victim offender mediation conference, you have situations where the offender is willing to give back, either returning the money stolen or going to serve some form of community sentencing or community service within the community, and just to show that the offender begins to repair the harm, and there's some form of reparation plan to respond to the harm that has been done. It also will help to reintegrate the offender back into the community, and the offender is held more accountable in a meaningful way than just going into the prison custody. Because obviously what we have at the moment, somebody is in custody for many years, he's released, he comes back into the society. Is he properly reintegrated? Is he rehabilitated? And if he's not, he's going to likely go back to crime. And so he's not, the regular criminal justice system that is run at the moment, which is, custodial, putting the person behind bars, may not be the solution to some of these crimes. At least, in my opinion, in the last how many years, looking at how we run the system at the moment, I don't think, I believe we can use other forms of non-custodial measures without necessarily subjecting it to abuse. Because with anything, with any reform, if not properly supervised or managed, may be subject to abuse. And so for that reason, restorative justice, yes, can be subjected to abuse if it is not properly managed. And that's why it is important to collect data, to collect statistics. Restorative justice for me has been part of what we've been doing for years. Even traditionally, our traditional rulers within the communities, they call a meeting of people within the communities, and they try to settle the disputes within that community. So it's a practice that has been with us. And I think this is just to now formalize, restorative justice practice is now to formalize that process and to ensure that we have a record of these cases when they are being settled, so that the system is not abused. If you have someone who has been through restorative justice system for a few times for different offenses, perhaps restorative justice may not work for that person going forward. So, but when you don't have data to capture that this person has once been through the system, then it's difficult to to sort of put in measures that will prevent the abuse of same. And I know that in Lagos, and I'm sure in the next couple of months, we will see more robust measures or protocols that will be put in place to ensure that to institutionalize restorative justice. Because at the moment, yes, we do not have, even though the ACJL sort of makes provisions for restorative justice practices, but there's no legal framework for restorative justice, so to speak. There isn't a robust legal framework for restorative justice. And I believe these are some of the things that the state is looking at. There's a restorative justice steering committee, which has representatives of the different stakeholders in the administration of criminal justice involved in the steering committee, and they've been driving the process of restorative justice in the state, putting things together. Dr. Bello is the GPP, they're all part of this steering committee in collaboration with Prison Fellowship in Nigeria to sort of drive this process and ensure that the process is institutionalized across the state. So it's not just going to be within the magistrate court as we have right now. There will be a center, and over time, different centers across the state where restorative justice measures, restorative justice can be collated. The statistics are collated from those centers, and referrals can be made. Whether it is post-charge, whether it is pre-charge, during pre-trial, post-charge, and post-conviction, restorative justice can be used as a tool to divert cases from the regular criminal justice system. I think that's what I will say on restorative justice for now because of time. But I don't know if we have any additions, comments, and how we can improve on the practices of restorative justice at the moment. If we have some suggestions from the participants.
Okay, so let's have questions and comments. You can just raise your hand so that we can unmute you if you want to add to the discussion. But I'm aware that although we've formalized the restorative justice mechanisms, restorative justice has been ongoing for a while. I know a few magistrates who have taken the lead on that. Immediately they have a case before them, a criminal case before them, and they see that it can be settled. They go ahead and settle it. But one thing I would like to ask, Bola, is you mentioned the steering committee. I don't know how, do you have lawyers who practice daily in courts in any of these committees?
Can you hear me now, Bayo? Sorry. I think I was unmuted.
Did you get that?
Yes, I did. You wanted to know whether we have lawyers who are in practice are part of the committee, the steering committee. Is that right?
Yeah, on all these initiatives.
Yes. I mean, like I said, it's it's a combination of legal practitioners, academia, the stakeholders in the administration of criminal justice, representatives of the police, the correctional facilities, the Ministry of Justice, Office of the Public Defender. So they are represented there.
Okay. So do we have any other comments on this, on the restorative justice issue? For instance, you said there wasn't any legal framework. Is that going to hold up the activities of the restorative justice courts?
No, it's not. It's not going to hold up the activities because, like you said, it's already being put to use. So it's really just having infrastructures in place to ensure that the center is set up, pending when the full the legal full legal framework legislation is put in place for restorative justice. But we have protocols. I mean, I mentioned to you that there's a practice direction used by the courts already to guide the courts, the magistrate courts, in using restorative justice. We also have guidelines, protocols that are already in place for will be rolled out very soon for the public to understand what guides the process of restorative justice, which will discuss the objectives, and the guiding principles. So yes, I totally, I don't think it will stop the process, implementation process, the full implementation process. One thing, sorry, Bayo, that I would want to throw out, I just want to get opinions from some of our lawyers, senior lawyers as well, whether if we have, because I understand that plea bargain judgments, and maybe this is one of the reasons why a lot of lawyers do not want plea bargain as part of, they're not so keen on plea bargain. Could it be, can we make recommendations that such judgments, those looking for sales, for example, that, judgments are, those judgments are recognized as part of judgments that can be submitted for those who are applying to become sales? Will this be some form of serve as an incentive to have lawyers or more lawyers use plea bargain and other non-custodial measures? I just want to push that point out there. What we think. Is there anybody?
Yeah, I think participants can raise their hands or just unmute their mics if they wanted to add. But Bola, I don't think that that would be a problem. I mean, a plea bargaining is part of advocacy skills, and if you're able to go through the process of plea bargaining successfully for your client, I think that's a plus for that defense attorney. And whatever they want, I mean, the outcomes is a judgment of a court, and judgment of a court is judgment of a court. I don't think they have categories where a specific kind of judgment is what should be required. If that's what's required for being a senior advocate, I think the Privileges Committee can look into that. It's something probably the Attorney General of Lagos State can look at in reviewing the provisions for or the qualifications for silk. But I think it goes without saying that any plea bargaining, a successful plea bargain, is a good feather in the court for the defense attorney, because he's also done his advocacy skills comes into play in successfully negotiating a plea bargain.
Thank you.
Hello? Hello?
Yes, good afternoon.
Good afternoon. I'm Grace Adenubi. I'm from the Legal Aid Council. I believe you can hear me.
Yes, we can.
Hello? I want to make a contribution as regards the plea bargain. I have used a plea bargain process, and I believe it's very useful. It's a quicker way of concluding a criminal matter, especially considering the kind of delays we see in court these days. If there could be that agreement between the Attorney General's office and the client, and it will be very useful, and matters could just be resolved faster. But I see that lawyers might find same as challenging you know, because some lawyers would rather want to have cases go on for years, you know, because some don't charge at once. Some could just be charging appearance fees and this way and that way. But I believe that it should be, the sensitization should be more, it should be higher. I don't just believe that the longer a case stays in court, the more fee for the lawyer. Lawyers should be more professional. You can charge your fees at once, have a more professional way of charging fees than depending on appearance, the number of times you appear in court and how long the case lasts in court. It just like the use of mediation is a faster way, and I believe lawyers too, most lawyers find it challenging because the matter just gets settled fast. So I believe that if we charge better, if we're known to be settling matters faster, whether by plea bargain or by mediation or by using restorative justice way, people will want to patronize us, you know, because they will have more belief in the justice system. So I believe definitely only few lawyers are willing to use plea bargain. But I like this program. I thank the organizers, and I believe that this should be more welcoming. Lawyers should use plea bargain more, you know, because if we look into cases, we could find very many scenarios where we could just use this and the case gets settled or concluded, instead of going all the way into trial to judgment, which could take years, especially even the way judges get reshuffled, and sometimes matters start de novo, or even if it continues, the distance could, the change and everything could delay matters the more. So thank you very much. That's my suggestion. God bless you all.
Well, thank you, Mrs. Adenobi. You've actually outlined a lot of the concerns in the administration of criminal justice there. So, Bola.
Yes. So yes, I totally agree with you. The last speaker from Legal Aid, and I mean, we want more applications from you. And I think, you know, for everyone who attended or who is attending today's session, I think, you know, we should take the message out there to our colleagues and get them to, you know, come on board with plea bargain application. The process is, I mean, is so transparent, and I just sort of demonstrated to you this, you know, by showing you how, as prosecutors, you know, we calculate sentence, some of the things we take into consideration when we recommend sentence, a particular sentence. And so I think the benefits are more of a transparent process, which I believe will lead to a reduction in the disposition time of criminal matters. It will also increase the cooperation and understanding of defendants. If we do a lot of, you know, if we apply the provisions of the sentencing guidelines as provided, and also and we are sincere in how we advise our clients, because I think sincerity and professionalism is very, very key. So if we have increased cooperation and understanding of the defendants, and I believe we will ultimately reduce the number of awaiting trial in the correctional facilities, and also the public confidence in the criminal justice sector will also be increased. So I think on this note, Bayo, I just want to say thank you for giving me the opportunity to come up and say one or two things. And I'm sure, I hope somebody picked up something. I hope I was able to give some information. I hope it was an informative or session for us all. I have learned from one or two of the participants as well. So I know that there was a comment in one of the comments in the chat box. Legal Aid did mention that they should be part of the Restorative Justice Committee. We note that point, and I'm sure we will bring it to the attention of the Honorable Attorney General as well. But let me say thank you to you, Bayo. and to the network which you set up, the people both both conveners who are on this platform, and also to the DPP who and the Attorney General management, basically in the Ministry of Justice, that gave me the opportunity to come up to speak. I hope that we will together increase the cooperation between the defense attorney and also the prosecution offices, and take sensitization. I'm sure when we roll out these sensitization programs, I hope that you all will be there to lend a voice to the voice that we are taking out there to all the magisterial districts and the high courts, the high courts as well, and also to the corrections when we eventually go there. We have been going there, and we will continue to engage with them. So on that note, I want to say a very big thank you for this opportunity.
Thank you very much, Bola, for your time. And we hope to come back maybe in a live session in a couple of months from now. But in the meantime, like you said, we're looking forward to this being taken to all the magisterial districts, where we can just have the lawyers walking to these sessions and learn one or two things. Thank you all for coming. I know it's not been easy. Data considerations, network considerations, timing. There's a lot of things going on out there, and it's not easy to just sit down in one place and listen to somebody speak. So thank you all of you that have joined. My greatest appreciation to you all and to you, Bola. Thank you very much. Have a lovely week, and we will continue this interaction as we go ahead. Thank you very much. Dr. Akim, thank you. Mrs. Adeyemi, thank you very much. Everybody that is here, thank you. God bless you all.